Hello, everyone. Nick Chavez here with Chavez Valko, your key to immigration solutions. Here, as always, with my law partner, Martin Valko. We're ready to answer some of your questions that we've been receiving throughout the last couple of weeks. These questions are not only coming from our clients, but also from our audience members. And we have just a few updates. But if you have a question about immigration law or a question about your immigration case, just feel free to ask away at any time, and we'll be happy to address them. Or you just can leave a question or comment for later. But just know that some of your questions may require more of an in-depth analysis, so we might just provide a general answer. But if you wish, you can always contact us for a consultation to have a more meaningful and private discussion of your case. And friends, before we begin, don't forget to subscribe and like to get the latest immigration news. We'll begin with some recent news about work permits. One of the problems we've seen in the past is USCIS would sometimes take a long time to renew someone's work permit. And this was very bad for those who were working and their families depended on their income, and their work permits had expired, even though they may have filed their renewal requests on time. And so basically they were left without a job at that point. The good news now is that USCIS recently announced that they are extending the work permit up to 540 days automatically if you have a work permit and are trying to renew it, and if you file it on time, that is before your card expires, they'll extend it up for 540 days automatically to prevent this lapse in work authorization, so you don't have to worry about losing your job. But this new rule doesn't apply to everyone. You know, for example, unfortunately, it doesn't apply to those who have DACA. We still recommend, if you have DACA, to file at least 150 days before it expires. And those with TPS, work permits, with respect to TPS, those extensions will depend largely on the specific TPS program. Most folks, who will benefit from this will be those who are filing for adjustment of status through a family member. So definitely a good, positive update. We also have, news about DHS announcing a final rule regarding the H-1B program and modernizing it and streamlining it to improve the process. Martin, you handle H-1Bs at our firm. What can you tell us about this new rule?
Hey, Nick, good seeing you again. And it looks like this is our last final show of the year.
Yeah.
So I'm really happy to be here with you and share some of our knowledge, experience, and be able to answer some questions. This H-1B, this final rule just dropped, I believe yesterday, and it will be enacted January 17th of next year. The USCIS is also requiring that a new updated form, I-129, be used following the enactment. And it really it's 140 plus pages, including comments and responses from USCIS. But basically, it is following up on a rule from February of last year. And it's basically modernizing the H-1B process, the H-1B classification. For those that are not aware of what it is, it's a specialty occupation classification for professionals. So for those that attained a bachelor's degree or its foreign equivalent, or a higher degree, of course, and in a specialized field or highly specialized field, and as well as master's advanced degrees. There's 65,000 spots open every year for the lottery that is being drawn every March. And then there's additional 20,000 for those that had attained master's and advanced degrees from a U.S. institution of higher learning. It basically, what they've indicated is that it's supposed to promote fairness and enhance integrity, increase flexibility, and streamline the process. One, I guess, big one is previously you'd have to have a specific degree in that particular field if for the position you're being sponsored. Now they've opened it up to related or similar degrees, not something just unrelated, but something that is related. They've also added a start flexibility date. So on October 1st, which was the beginning of the fiscal year, the status will change. If, for example, there were an F1 students, they would change to an H1B, and there is a flexibility. So you could basically request the start date beyond October 1st. Last year, they've started, actually, this was this year, so fiscal year 2025, the selection process in the lottery was, and the registration process was beneficiary of the applicant foreign national centered as opposed to the employer, and how many employers there were that registered you in the lottery or the foreign national. So from last year, there was a significant drop in these registrations. I think we went from 750 or close to 800,000 down to 400 something. So the odds of being selected greatly improved once the selection process centered on the actual foreign national and not on the number of registrations. Another requirement that was put in was a passport requirement that basically if a person had several passports, they could not use it, and they were able to use just one passport. So they really didn't game the system. Another good thing was that they are giving deference once again to prior decisions. So if the same employer had sponsored the same employee and they were filing for an extension or a promotion, which requires an extension with the same employer, they could just defer to the prior decisions, prior approvals, and not having to fully go in and try to adjudicate it and use. We're not going to defer to the prior decisions like they used to. With an F1 with foreign students, and really those are the ones that primarily covet the H1B classification, because those are the ones that go from the F1 being a foreign student to optional practical training, STEM optional practical training, STEM OPT. Those are employment authorizations following your F1 student status, graduation, and the OPT and the STEM OPT, which is an extension of the work authorization for another 2 years for foreign students that graduated from STEM degree programs. They are basically are able to extend their grace period. So typically, grace period is a period, or basically when you or your work authorization expired, there's a cap gap provision that got you continue to work from the work authorization from the F1 program to H1B to October 1st. But in some instances, those petitions were not approved by October 1st. So let's just say a petition for the H1B, if you were selected in the lottery, got submitted and got selected and was being adjudicated. If the employer did not pay additional premium processing fee to have it adjudicated within 15 days, I wouldn't say always, but sometimes it would lead through processing beyond October 1st, and that foreign student had to stop working, which obviously created some issues, problems for the employer. So now that was extended. So, a couple of good things overall. And again, I really haven't fully dove into it, but that's kind of those highlights that we're looking at that will take place on January 17th of next year.
Yeah, certainly some positive developments now that the administration is winding down. Definitely helpful for immigrants. We are receiving some questions about this parole in place program that was announced over the summer, and it was implemented in April. As we know, last November, a judge ruled against the PIP program. This is PIP stands for Parole in Place, and it's the program under Biden's Keeping Families Together initiative, which basically allows individuals to apply for a parole while they're here in the United States. And that would have formed the basis to apply for a green card here through a family member. It was a great idea. It was very beneficial. You know, over 800,000 families would have benefited, but a judge out of Tyler ruled against it. And the Department of Homeland Security didn't appeal it. So it's pretty much dead on the water. We're waiting for right now is for USCIS to provide additional information. The last update we had was back on November 13th. If you see their website, they pretty much said that they're going to wind it down, especially now since the case was not appealed. And we have to wait and see what that means. We don't know what the process will be. If they're going to give refunds, we just don't know at this point. We'll just have to wait. So that's the update on PIP for now. We are also receiving a lot of questions about individuals who have DACA and they want to travel, and that is referred to as advanced parole. People who have DACA could apply for advanced parole under certain conditions. And we're seeing a lot of comments and questions, especially now they're on the internet, and they're worried about January 20th. That date is looming. There's a real sense of anxiety. We don't know exactly what the future holds for advanced parole under DACA under the Trump administration. Martin, what can you tell us about the requirements for requesting travel or advanced parole if you have DACA, and importantly, you know, what is the difference between a standard and an emergency parole request that we're seeing our clients, you know, raise and share that information with us?
Yeah, so DACA beneficiaries have had this opportunity for several years. So once you have DACA and it's basically been extended, or you have the coverage for the time period that you're trying to travel, you have the ability to request travel authorization, or as they call it, advanced parole, with USCIS based on three grounds: humanitarian, employment, and educational grounds. So I'll start from the end. If you are part of a program, a university, high school, whatever it may be, and that requires you to spend time abroad, and we've had several clients that took advantage of it. You basically apply to USCIS with the I-131 form. Now it's a new form that neatly lays out, you know, what type of parole you're requesting, and you submit it to USCIS with the supporting documentation. And currently, the processing times have advanced. It's sped up from 8 down to 4 months on average that we're seeing in our firm. And if it's granted, depending on what you requested, you may have just kind of like a one-time trip that you have to travel and return by a certain date. For employment purposes, again, we've done that for our clients where the employer required that the employee, the DACA recipient, travels, and that was those are fairly straightforward requests. And then you have humanitarian basis. So anything from attending to your parents, grandparents, medical procedure, to attending funeral, unfortunately, and in some circumstances, to attending your own medical procedures, dental procedures. And so when they can say that, look, we've shopped around and the procedure is very expensive here, but we found dental surgeons or doctors in other countries, then they, again, based on that, and it has to be fairly well supported, and you know, once decision is made, the person is able to travel again. You want to make sure that you are otherwise admissible, you know, that there are no certain crimes, that you don't have outstanding order of removal or deportation. And so those are things that should be really fleshed out and vetted prior to even applying for it. I've was successful with a couple of clients that were, or trying to pay respects to grandparents passing several years ago. I think this was over 10 years ago, and we knew this was going to be a tough time. They just wanted to try it. And immigration at first did not like the reason, but the clients were able to secure a memorial service and paid for the services. And I've made an argument about the significance of that memorial service. It was being held on the Day of the Dead, and it worked out, and they traveled and came back. And so that's your typical advanced parole request through USCIS. Then you also have what we call emergency advanced paroles that are available to those with, for example, pending green card applications, adjustment of status. But here, particularly with DACA, the person basically has to reach out to USCIS either through their 800 number or through their chatbot to request an expedited appointment at the local field office, and they'll have to state the reason within, typically a couple of days, day or two. The officer gets back to them and tells them whether they found that reason to be sufficient. If not, you can try again. But if it is, then they'll give you a date. It may be next day, a couple of days, and then the person attends and makes the case for the emergency parole. So you don't even necessarily have to submit it at the field office or at the service center. I'm sorry, but you make that request because you are eligible to receive it because you're a DACA recipient, and so you go to the local office and then you make the case. And recently we've got several of these approved at the Dallas field office. I participated in one of them where a grandfather was having some medical issues, and it was elderly grandfather that it did not look that he would last much longer. And so I actually had to make an argument with the supervisor and try to show, because the letter from the doctor wasn't very specific. I mean, on its face, you knew that the person is terminal and has days to live, but they specifically were asking, well, what is the prognosis? And so I had to nicely tell them that if you read the letter, you can conclude that that person will not live for much longer. So at the end, we were granted, the client was granted the parole, was able to travel and see the grandfather, and then safely come back.
Yeah. And that's good. I think what's important as well to know is this emergency request, right? It's a great way to get the travel permit on an urgent basis, and many people are looking at that as a way to do it before the new administration comes in. But we do have to show that it's an emergency, and what is an emergency depends largely on what the local field office thinks it's an emergency, and that could change. That policy of what constitutes an emergency changes. So I think it's important to keep that in mind. It's not an automatic thing, and there are denials because it doesn't measure up. So that's something to consider when you're weighing whether you should file the advanced parole through the standard process or you should do it under the emergency. And sometimes you can do both, but it's something you should definitely keep in mind. Moving on, one of the other questions, and I think this is probably more prevalent, is all the fear, the rhetoric about the mass deportation. We get calls every day. Clients were just scared. Some of them have deportation orders, others don't know, and they're wondering, what can they do? What should they do to prepare themselves? And we always talk to them about their rights and all that, and it's important to speak with a lawyer to get as much information. I mean, what is your opinion on that? How do you think, or what should individuals do rather now to prepare, especially if they have an order of removal?
Well, you wanna meet with an experienced attorney who will fully evaluate the case, and if they have the records, and those are from various agencies that the person may have come in contact with, you want to fully, just like before doing a surgery, you want to run tests and evaluate, what the options are, what would the strategy be, because I think the incoming administration now is pretty brazen and strengthened by their prior experience, and now it seems like they're coming in with, I've heard, hundreds of executive orders, particularly on immigration, that I think will at first go after people that have outstanding orders and possibly some type of criminal convictions. Obviously, those that are detained, that are here, they're non-citizens, they may not have any other relief. I think they will be the priority number one that they will go after, and the number is somewhere in 300,000 or so. So, it was from the interview with Stephen Miller, the future special advisor to the president, or the future president. So, really just look to see what are the options. Right. There are specific steps that would need to be taken. You may have somebody living together as a common law couple. They may be married, but nothing was filed, no petition, no I-130 family petition was filed, and but there's an order. So you want to look at it to see, okay, in which order you need to take those steps. Prepare the motion to reopen, reach out to the government attorney, office of the chief counsel, file the petition, perhaps have the application for stay of removal ready in hand, just in case the person gets detained. So all those things are really, really important, for people to evaluate, for their attorneys to sit down with them and look at their records. If they don't have records, let's get them right away. They take months, sometimes close to a year. A lot of times they don't yield the initial information, and our practice at the firm is always appealing it, so we can have another go at it. And most of the time we get the information, and with that we can sit down and based on our 20-year experience as a law firm, and collectively we have some great minds that we could then devise a plan and try to execute it. Be ready. Download our app. Our clients get our app, Law Pilot, and the services as part of the legal services. So that if they have a problem, if they have an emergency, if they get pulled over, if they get detained, if there is some type of visit, raid at the workplace, we're notified and we're able to step in immediately based on what our records and notes show.
Yeah, and that app that we have, and I'm trying to pull that right now, just to clarify, that app we use to share with the general public regarding their rights, because it has a lot of good information on what you should do or say if you're pulled over, if ICE comes knocking at your door, what you should do, and it has some features. But there is a red button, right, that we developed where for our clients, if our clients are pulled over or they're detained by ICE, they can alert us as their attorneys for us to respond and act on their behalf. But it's a good feature if you have an attorney. And if you're interested, you can show your attorney that, and we'll be happy to show your attorney how to use it and what are some of the features. And I'm trying to pull that up, Martin. For some reason, I'm not able to find it, but I'll have the link under the description. But speaking of deportation, you're talking about people who have deportation orders, and it's important to seek legal counsel now, because the FOIAs can take months to get. If you have DACA, right? If you have DACA or TPS, you're feeling okay now, but we know that DACA is not going to live forever. We know that these TPS programs are not going to stick around forever. And so what's left is a removal order. So if you were ordered deported, or if you're unsure, and if you have DACA, I think now's the time to speak with someone and try to get your records through FOIAs. As we said, that time sometimes it takes a while to get those, and there could be options. I mean, if you have if there's a defect in the proceedings, we can look at the possibility of reopening, or we can reach out to the government counsel and see if they're willing to terminate if you have if you're eligible to apply for a green card through a family member. So I think the time to act is now. One of the things we're going to be hearing a lot about for those who don't have deportation orders, they have rights. And one of the rights is they have the right to have a hearing in front of the judge. Usually when you have an order of deportation, your rights to appear in front of a judge and ask for a remedy to stay are very, very limited. They're very limited. And under this administration, they're going to execute those orders. We know that. That's not some kind of great secret. But if you have never been ordered deported, for individuals who have been here a long time, who have family ties here, have work ties, who have community ties, and have qualifying relatives, specifically spouses, children, or parents who are U.S. citizens or legal permanent residents, there could be relief. And one of the important things is to insist on speaking with a judge, or speaking with a lawyer, or having a hearing before a judge, and not sign away your right to appear before a judge and ask for that relief. Sometimes the agents, the CBP office, the ICE officers will say, "Hey, here, sign this." And if you sign it, you're really signing your voluntary departure. And that means you're going to renunciate your right for any relief in court. But this relief is called cancellation and removal. You're going to hear a lot about that. It's very tough to get because one of the requirements is show that your family members will suffer, and it's one of the very highest standards of hardship you have to show. And this is the reason why a lot of people don't prevail or don't win these cases, is because it's very hard. But at the very least, you're not going to be detained if you don't have a criminal record. You're going to have a series of hearings, and it's quite possible that you have your last hearing after the 4 years is up with Trump. But during this process, the irony is if you qualify for cancellation or removal, you might you'll have a chance to apply for a work authorization. So that's the irony. So very important. Know all that. Have a plan, as Martin said, and we do have information on our app. And as I mentioned, I'll have that on the link.
I just want to fill in and give kudos to our removal team and specifically Ann Miller, managing attorney, who's I believe recently she's gotten 3 to 2 grants of cancellation of removal under the Rule 42B for non-lawful permanent residents. And again, as Nick mentioned, the highest level of hardship. It's exceptional and extremely unusual hardship to the qualifying family members, and one from a couple of years ago. So those are very, very important grants that don't happen often, and so the clients are extremely happy when that happens. Yeah,
and now I finally found it. So this is the code for our app. Just to check it out, the information that is useful there is information about your rights and what you should do, what you should say. That red button is for our clients, that we offer that service for our clients. This is a feature that Martin and I developed. But if you have a lawyer who's interested, have him or her call us, and we'll be happy to help and show those features.
And those lawyers can sign up and they can provide that service. And so it's fully customizable. For example, if the person does not want to speak to a law enforcement officer or doesn't speak English, they can press a button and
Yeah.
and it's playing that for the officer. It's being recorded. So one of the things that is so important on this red button is that not only does it notify us through a text message or an email, and also the emergency contacts from the family of the user, it also shows us on the map where the user is located directly on the Google Maps. And we're also able to listen to the audio that as soon as the button is enacted, the audio records and uploads to the cloud as soon as there's a cell coverage. And within seconds, we at the firm, our 24/7 response team, is able to listen to the encounter. And at that point, we know what we need to do, because we can just access our notes, access the case history, and be able to react and reach out to the user, reach out to the family, and start attacking this problem. And so again, as Nick indicated, the red button is a notification for us of our current clients, but anybody is able to sign up, register with the firm, have access to know your rights, to continue or to receive immigration related breaking news and anything that we deem important, and other things like, am I a potential applicant for some type of being a victim of violence? Do I qualify for a U visa? Do I qualify for VAWA under the Violence Against Women's Act? So it's loaded, and we keep adding new features and new content. So it's educational, and it's also protective from encounters with law enforcement, and of course when person is in some type of a danger.
Yeah. We have a question from Lydia Sanchez. She came to the United States with an F1. And she's F1 is a visa for students, and she's working on a petition for R1. This is for religious work. Should she wait in the U.S. while she gets the answer from USCIS? What say you, Martin?
Yeah, so Lydia, thanks for the question. And so, and I personally used to be an F1 student myself. I've gone through several types of classifications. I held H1B and several OPTs. But basically, an F1 is a foreign student. Once the program completes, the student is able to apply for OPT work permit and on. If they don't, they have a grace period. But while they are in status, because you have to be in status meaning maintaining the 12 hours, graduating, et cetera, and then while the person is in status, is able to apply for the R1 classification, which is a religious worker classification. If you're in status and you are in the U.S., then you are able to apply for a change of status. So your status upon approval of the R1 petition will change from an F1 to an R1. So as long as you are in status, you are able to wait, even though you're no longer in school, but you are in status when you filed the R1. It will take several months. There are some restrictions about premium processing, which is the quick 15-day processing. It only applies to certain petitioners, certain employers, but you could wait for the decision. For those that are not in status, for those that are not here, they can apply for consular notification. So upon approval of the petition, then the person can apply for the R1 visa at their home country, at the U.S. consulate or embassy.
Thank you, Lydia, for your question. One of the other things we've been seeing, Martin, or some of the comments and questions, from our clients and viewers, is, we talk a lot about the changes about the incoming administration, and what their focus is going to be immigration enforcement, right? Deportation. But there are other changes that we are likely to see. We've been through the first administration with Trump, and we're very aware of what might be coming down the pipeline. The whole idea is really be restrictive, scrutinize every application, and that causes problems, right? So it's more of an anti-immigration take on things. What are some of the things that you're worried about oh man, this is going to be a pain in the butt? What are you losing sleep on in terms of potentially new policies?
Well, I think going back to the non-applicable being put on every empty field on these forms, which there could be hundreds of these, and so that was something that I think it was Stephen Miller that came up with it, which gave the agency ability to just reject or outright deny, but mostly reject the application or whatever it was, a petition application. And so, I mean, that was just something, I don't know, not too wise, but again, it was just very restrictive. They just wanted to see how they can make it more difficult for people. Another one was public charge, Form I-944, that it seemed that it seems that people were applying for a mortgage where they had to show that they would not become a public charge of the U.S. government. And, you know, is that going to come back? Probably. And so that adds additional time processing and certainly sifting through documents and, of course, getting those documents. So that's time consuming. It could be discouraging, and some people may not qualify. Some people, you know, could appear to be a public charge, and then they'll have to put up some kind of a bond, something so they can come into the U.S. I think we're gonna see less exercise of discretion by the government prosecutors, by the government attorneys, the prosecutorial discretion. I think it's just going to be focus on, you know, how can we make it more difficult? You know, the border issues are coming up, and I think even the current president it made it a little bit more difficult in the last few months, and Trump's going to love it, and they make it even more difficult. So, but we've been through it. We're just going to have to adjust, and we will adjust because we're defending our clients and clients' rights, and you know, they will not defeat us. But then, you know, I read an article where incoming president had indicated that he's going to reach out to Democrats and see if they can do something for legalizing Dreamers, DACA recipients, and those that would qualify for it. I mean, he offered it in 2018 and 2019. It was shut down by the Democrats, and he's reaching out again. So, you know, there was that. Then there was let's give green cards to foreign students, these F1s graduates, so they don't go back if they are ineligible or they are not picked up in the lottery for H-1B, so they don't go back home or to different countries. So, you know, we've educated them, and now we're just going to send them back. So, again, a lot of things were kind of thrown around, and we'll see what's going to stick and what they will want to focus. What their priorities in immigration will be.
We know the push is for more of a immigration enforcement, a general anti-immigration stance. We know that that's what's going to, you know, overall. But there are going to be nuggets of hope, I guess, if you want to describe it that way. There could be some, there could be a little silver lining in some of these situations here. You mentioned Dreamers. I think Dreamers, those who have DACA and those who would otherwise qualify for DACA, but who missed out, and TPS holders, I think that if anything, they are on top of the list of groups that could see some sort of bipartisan effort, because there's support on both sides. And, you know, Trump, if you can influence them, and there's lobbying groups, you know, Elon Musk or whoever's out in his circle, is able to influence them and say, hey, this is a good thing, and they will love you for it. You have to include that. Then we could see something. But I think the focus first and foremost is obviously immigration enforcement and tightening some of these policies. You mentioned about that policy that we dreaded, where If you file an application for an immigration benefit, and if you don't have all your information down correctly, or if you make a mistake or you make an error, you know, usually immigration is going to give you a chance to correct it, right? They send these requests for evidence, and you have a chance. You have 3 months to correct it or supplement the record with whatever they're asking. But not so much anymore. So it really puts a premium on making sure that you have everything prepared before you file that application, because it could be denied just outright without any opportunity to correct it.
Yeah, and you mentioned enforcement, and one thing I want to highlight, and this has been happening, you know, during Trump, will be audits of employers, right? Mm-hmm. There will be these raids, and that has happened before, and we've represented corporate corporate entities, employers, and that is a real thing where you know, people could lose half of their workforce depending on the industry. Yeah. And so what typically happens is if they find out that the employed people are working without authorization, right? That's step number one. They're going to point them out and give the employer some time. Typically it's a couple of weeks or so where they have to, you know, the employer then takes to the employees and talks to them and said, hey, could you rectify it? Could you look at it? You know, was there an error? Wasn't updated, or tell me what's going on? And sometimes the employees are able to correct it and come back, and other times they don't show up because they know that they have been quote unquote caught, right? That they are there now without authorization. So that's step one. So the employer is about to lose a percentage of their workforce because of that audit. But secondly, when they review their I-9s, the employment authorization verification forms, which is required for every W-2, for every hire, for every employee, if they find certain errors, and those errors are substantive errors, you can get, or the employers can get fined for it. So it's like insult to injury. It's like a 1-2 punch. Yeah. Not only am I losing my workforce, I am getting fined for improperly completing these I-9s. And so one of the services that we also offer is these internal audits. We call it soft audits of the I-9s, where we review the documentation and make any types of corrections on those I-9s. So if there is an audit, at least the employer will not get penalized for that, especially employers that have had audits in the past, and now they are looking at some stiff penalties. Yeah,
that's a good point. Yeah, it's more scrutiny, more field investigations. You know, right now they're skipping interviews for certain applicants. They're not really pressing for interviews for individuals who are applying for a green card through a son or a daughter. But that could change. We could have interviews for everyone, and what happens if we delays, longer processing times, and the irony is, didn't we pay? Wasn't there a fee increase this past April that supposedly was going to help reduce the backlog? Yeah, it's crazy times. Well, I think we might have a question here. Okay, so this is from Lydia again. So she's adding, they approved the visa, and does she have to go to her country to receive it?
So Lydia, if you're in the U.S., you're applying for a change of status from F1 to R1. You will need the R1 visa upon departure. So if you are going to travel beyond Mexico or Canada for up to 30 days, in that case, you can use what's called the automatic visa revalidation, where you don't have to get the visa. But if you go beyond, or if you stay longer than that, you need to apply for the visa. So you do not receive a visa in your passport in the U.S. You do that in your home country at the U.S. consulate or embassy. Now, there is a pilot program that has started, and I'm not sure how far it went, for certain H-1B grantees or H-1B beneficiaries from selected countries. It was a pilot. We don't know the results of it, where people could apply for a visa in the U.S. so they don't have to travel, because that leads to delays. There's administrative processing, and that disrupts workforce. And so, but no, when you get the change of status approved, you can stay here. You can stay here for up to the admission period. But if you do travel and you don't live in Mexico or Canada, let's just say you're from Colombia or Spain, you will have to then apply based on the approved petition at the consulate or embassy for the R visa.
Yeah, Martin, we've been practicing long enough to remember that time when we were able to apply for the visa here stateside without having to leave outside the country. Those were the good old times. And there was, there seems, under the administration, the current administration, that they wanted to move toward that again, streamline everything. But now, after the elections, it's just kind of has thrown everything. It was just kind of a wrench thrown in there, and it's one of those unlike. I don't know if that effort is going to be followed through under the Trump administration. We'll have to wait and see. Thank you, Lydia, for your question, and folks, thank you for listening and watching us. Please remember to follow us. Hit subscribe and leave a comment or question. Hit like. We really appreciate that. Martin and I, we love sharing our insight and dissecting the information for you. I think it's important to have this information, as they say, right? I sound corny saying it, but knowledge is power, especially now where it is vitally important that we are prepared. If you have a history with immigration, if you're unsure, now's the time to call a lawyer and get your options. Get information about what your options are and what you should do, and follow through. And with that, Martin, you're going to Slovakia for Christmas break. I'm headed to El Paso, and I wish you a Merry Christmas and a Happy New Year, and same to everyone.
Likewise to you, Nick, and Happy Holidays, Merry Christmas, Happy New Year to all of our followers, clients, friends. It's going to be a difficult 40 years, but we will persevere. We'll be here for you, and you can count on us. So thanks again, and safe travels for you, Nick.
Yeah. Thank you, everyone.